Good evening, everyone. Thank you for being here tonight. At the risk of not speaking behind the judge's backs, I'm going to stand up here and introduce everybody tonight. Thank you for bringing the weather. Thank you for skipping at least the beginning or the first or second hour of the State of the Union address tonight to be with us tonight. You are in for a treat. We are here with those individuals who make up the backbone of our judicial system. Tonight, you're going to hear from a panel of 3 judges who ensure that the rule of law is upheld, who ensure that people have a voice, who ensure that people's disputes are heard in a way that comports with the Constitution and the way that we have chosen to govern ourselves. So we are going to hear all about their cases. They've handled complex cases. They've handled evolving issues of law. And they've done it in a way that expresses their humanity and their adherence to the Constitution. Tonight, they're going to let us behind the scenes a little bit into what works in their courtrooms, what doesn't work in their courtroom, and we're going to hear their opinions on different things. I should have introduced myself. My name is Chris Stecker. For those of you who don't know me, I am this year's president of the chapter, the Northern District of California chapter of the Federal Bar Association. It's my privilege to be with you tonight. The Federal Bar Association is obviously helping to put on tonight's event, along with some firm sponsors whose names you saw on the poster on your way in. I would encourage all of you to become Federal Bar Association members to the extent that you are not already. I would encourage you to encourage your fellow lawyers and members of your law firms to become sponsors, because you get to attend events like tonight. You get to attend a couple of other events that I'm going to talk about before turning this over to our wonderful panel. The first is I want to talk about our judges' dinner, which is we get to see and interact with judges in a little bit more of a relaxed environment at a dinner at Palio. That's March 11th. That is for members only. So if you have not signed up to become a Federal Bar Association member, now is the perfect time to do it so that you can register for this dinner where we'll get to actually break bread with the judges of our Northern District bench. The next event I want to talk about, going back in order, is artificial intelligence program that we're putting on actually a week from this Thursday. It's March 5th. And I just wanted to plug a little bit that AI isn't just shaping how litigators work, it's rapidly reshaping what courts expect. On March 5th, 2026, join us in this very courtroom for a fast-moving seminar that breaks down the most recent influential case law in artificial intelligence, from sanctions for AI hallucinated citations, to judicial opinions on disclosure obligations, confidentiality risks, and evolving standards of professional responsibility. We'll look at what judges are actually saying, not what the tech blogs claim, and what it means for your motions, discovery strategy, and client counseling. Expect practical takeaways, a few surprises, and possibly the only time you'll hear AI and harmless error in the same sentence. By the way, everything I just read to you was created entirely by artificial intelligence because of what's going on. With no further ado, let me please turn this over to Matt and our terrific panel of judges who are going to take us to tonight's program. Thank you.
Thanks so much, Chris. And these mics are quite loud. My name is Matt Yelovich. I'm a partner at Cleary Gottlieb here in the Bay Area. I'm delighted to be moderating tonight's panel. It should be an interesting conversation about practice here in San Francisco Federal Court and some of the advice and experiences that our judges bring to bear. I'm thrilled to be joined tonight by Judge Susan Ilston, who's a senior United States District Judge here in San Francisco. Judge Ilston was confirmed to the bench in 1995 and assumed senior status in 2013. Before joining the bench, Judge Ilston was in private practice in Burlingame for over 20 years. She's a graduate of Duke University and Stanford Law School. Judge Rita Lynn is a United States District Judge in San Francisco. She took the bench in 2023 after serving as a California Superior Court judge in San Francisco from 2018 to 2023. Prior to that, Judge Lynn worked in private practice for a law firm in San Francisco for 10 years and served as an assistant United States attorney here in San Francisco for 4 years. and she is a graduate of Harvard University and Harvard Law School. And Judge Joseph Spiro is a United States Magistrate Judge in San Francisco. He was appointed in 1999 and served as Chief Magistrate Judge for 8 years from 2015 to 2023. Prior to his service on the bench, he worked in private practice at 2 different law firms and trained as a mediator before serving as a mediator as part of the Northern District's Alternative Dispute Resolution Program and as Judge Pro Tem in San Francisco Superior Court. He is a graduate of Grinnell College and Columbia Law School. So welcome to our judges. Thank you so much for doing this tonight, and thank you all for coming. So the goal for tonight is to learn a little bit more sort of, what works and what doesn't in practicing in federal court here in San Francisco, or at least observations that you all have had at your time on the bench. And maybe get a little bit of advice along the way. I want to start by asking each of you a question that was not mine initially, but I think will help lower the temperature for folks out in the reception who want to come approach you for a conversation, which is, can you give the audience maybe a fun fact about yourself or something that is not on your courthouse bio, but something that might be interesting for the audience? Judge Lynn, can I start with you?
Okay, in full disclosure, I propose that Matt ask us this question because I think it just makes it easier for you all when you see us to figure out a way to talk to us sometimes. My weird fact is that I'm a fantasy football obsessive, and I am the commissioner of the Federal Judges League in the Northern District, and we call ourselves the Justice League.
Perfect. My fun fact also applies to Judge Ilston. I hope I'm not stealing your fun fact.
Could be the only fun in our lives.
It might be.
Go ahead.
We are on the House band for the Northern District of California. As some of you at least know, the recusals. My first experience of being on a band playing for an audience was in college. I was in a band, the name of which I will not repeat in public. But we didn't actually have our own instruments. So we would go to concerts which were being put on by the college, and during the intermissions, we would hijack the instruments on the stage until they threw us off.
Oh, that's a fun fact. And he and I are both on the court band, so we share that fun fact. We share one other fun fact, and this is really fun, which is that we are both recently have become grandparents. And there is nothing in the world more fun than that.
I know that's hard to believe. We don't look old enough to be grandparents.
So can I start by asking each of you what made you want to become a judge? Judge Ilston?
I was an undergrad at Duke, that's in North Carolina. And so I needed to figure out what to do with my life. But at that time, I thought what I would do would be solve racial discrimination. So that's what I went to law school to do.
How'd that work out?
Not so good.
Yeah.
The question is why did we want to go to law school, or why did we want to become a judge?
Why did you want to become a judge? But either
Okay.
one is fine.
So one thing that was odd for me was that it was totally not on my radar screen. Honestly, I didn't picture myself doing that because I didn't believe that was within the realm of possibility for someone who looked like me. And I didn't grow up with any lawyers in my family. I just didn't think that that was something I could aspire to. And then I literally got this flyer in my email from the Asian American Bar Association, and it said, "So you want to be a judge?" And this is like at a time when I decided I probably wanted to leave private practice and do something in the public interest area. And so I looked at it was not fictionalized communication in any way. But I was like, then I started thinking about it. I went to an event, and it made me realize I'd always thought it was something that was for the world of people who are politically well connected, whose families know someone, know the government, who are involved in important political things. And I hadn't registered that that was something that could be within the world of possibility for me. And so I really commend the Bar Association for having shown me that that is something that I could be interested in and could consider. And it's not so, I didn't put in an application for years after that, but it had just never crossed my mind before that. And so now I try to do a lot of those. So you want to be a judge events, because I figure that there at least must be some people out there who are in the same bucket as me.
Yeah, I think there are a lot of people in your boat and similar boats, I mean, that haven't really considered it for themselves. I know I didn't until way late, not way late, but until I was well into my career. And it was, I noticed, I think I saw Maria Elena James got appointed. And I had known her before, and I'd been in front of her in court, and I liked her a great deal. And so it was the first I noticed that the magistrate judge position in the Northern District was kind of an interesting position. And it was true at the time that while I loved a lot of the things lawyers do, there were a couple of things that I was not crazy about. The first of which was having clients. They're very demanding. And second, you have to conform your positions in court to their point of view, to what helps them. So while that was kind of interesting, and there are lots of other interesting things that lawyers do, those two always sort of bothered me. And so when I saw this, I thought, this is a great idea, because I only have to advocate for the right result. I don't have to advocate for this and for that, just for the right result. And so that's why I started to go down that path. And after 3 or 4 rejections, I'm looking down the table at Sue, because she was on the panel, in favor of some people who were just wonderful, who got the job, I finally was appointed.
So Judge Spiro, let me stay with you for a second. What attributes do you think make a good attorney?
That's pretty wide open. So, I only know a narrow slice of what it is to be an attorney. And especially these days, the narrow slice I know is what happens in the courtroom. So I can only speak to what looks good from my perspective happening in the courtroom. And the good attorneys, you can tell when they walk into the courtroom that they're good. They understand that the point of being in a courtroom is to persuade some human being, and that everything you do in a courtroom should be aimed at that goal. So what you wear, will you look when you walk into a courtroom? There's people who walk into the courtroom and they just look like they've taken over the courtroom. It is, good attorneys have that sense that everything I'm doing now is about persuading, maybe it's the judge and maybe it's 12 jurors, but some human beings about what it is. Lots of people with less experience in the courtroom forget that. They think it's about argument. They think it's about lining up bowling pins and knocking them down. It's about persuading an individual human being that you're right. And that's a complicated thing that is not just about making an argument. So I would say those that have that kind of emotional intelligence and that focus are really good.
Judge Lynn?
Yeah, I really agree with that. I think a huge component of being a great advocate is actually being a good listener and being able to put yourself in the shoes of the person who you are trying to persuade. So if you're coming into oral argument with a judge, I think coming in and having your antenna up for what is it that the judge is trying to ask me for? Is this a situation where the judge believes that the equities of the case are with me, that they're struggling to find the legal hook to rule in my favor? if you can see that that is where the argument is headed, then you can put yourself in the helpful position of providing that legal hook. Or if you think the judge is going to be particularly worried about the next case down the road, because if we take one step down this garden path, the judge is going to feel like, well, then I'm going to have to rule in favor in this particular way, and for a bunch of other cases where the equities might be really different. I think you need to listen for that, anticipate what it is that the other person is worried about, and then proactively address it. And I think it's the same skill that you use with a jury, with a client. I think when you walk in to begin a trial, the best trial lawyers put themselves in the position of jurors who have heard nothing about the case and know nothing about what is going on. And they don't like brain dump, all 700 facts of the case on the jury in the first 10 minutes. They build a narrative. They recognize that the jury is in a position where it's overwhelming for them. Many of them have never been in a courtroom before. And they kind of mete out the information in a way that allows people to digest it and understand it. And they structure the trial to sort of build on the information that they started with. And I think a lot of that is really about being able to perceive where the other person is likely at, and maybe get at some of the unspoken needs that they have that they might not even know about. And I really think that listening and empathy is actually what really distinguishes the great lawyers that I see.
Judge Olson?
Well, all of that, all of the above, plus I'd like to speak up for hard work. Good lawyers work really hard. It helps to be reasonably bright. You don't have to be brilliant, but it helps to be reasonably bright. Work really hard, and then you have to have integrity. We had a list of questions that Matt said he might ask us, and I found as I looked at them that the answer to almost all of them was, do not lie to me, tell me the truth. And that it's a good way to start. It's a good way to end, and it's a good middle for being a good lawyer. Times I think are hard right now, and the judiciary is working really hard to keep up with the times. And right now, more than ever, I think it's critical that lawyers be good lawyers. You need to be persuasive, as Rita says, but I think it's really critical that we remember that we are all playing a role in a system of law that requires that we have integrity, that we follow the law, and that we help each other in that endeavor. I think we need to help our clients in that endeavor to make them understand what the law requires, and we as lawyers and officers of the court will help them do that. So that is kind of a commercial aside at this point, but I do think now more than ever we need you. And we are grateful, and I'm very grateful to practice and to be in the Northern District, because I think we have outstanding lawyers here who exemplify the things that we'll be talking about this afternoon, which is hard work and integrity and persuasive power and all of that. But we can't take any of that for granted. So I'm grateful that you are here and that we are here where we are, but we need to work really hard to keep and preserve the system that we have.
Can I just echo a little piece of what Judge Ilston said, because I think it's really important. It is a piece that is not just, it's important to all of us. It's important to our world. It's important to our children. It's important to our grandchildren. It's important to your clients. It is consistent with the best path for your clients. Because if you come into a courtroom and you behave in a dishonest fashion or a disreputable fashion, you lose your credibility with the court. And there's no quicker path to a loss than losing credibility with the court. And you can lose it in any number of ways, but it's absolutely critical that the court have the opinion that you are a person that's one-on-one, that can be trusted. That when you say something, I can believe that it's true, that you're not trying to mess around with me, that you're being honest with me. Because the moment I get a smell that some lawyer is doing something different, I stop listening to them. I stop listening to them. I figure it out for myself, or I figure it out from the other side, but they have no role in the process. And so I think credibility is critical for the country. I mean, honesty and integrity are critical for the country and all of us, as Judge Ilston said. It also is exactly the right way to serve your clients. Speaking from a person who never serves a client.
So,
I think it's important to recognize the whole spectrum of what Judge Spiro, Judge Ilston are talking about in terms of maintaining credibility with the court. I mean, I'm fortunate enough, I feel like there have been very rare occasions where somebody has actively misrepresented something to me in court. But there have been lots of times where folks have lost credibility in court for reasons, for sins that are less than that. And I think one of the important areas in this vein is folks who won't answer a direct question that I've asked. And I have to ask it a couple times before I get the answer that is just the direct answer. And when I hear that, it makes it hard for me to hear anything else the person is saying to me, because I don't want to hear the other thing that you have to say to me until you answer my question. So I think part of it is, being willing to concede the facts that you just can't argue because they are what they are. And having the confidence to just do that and own that and tell me why it doesn't matter. So I think that that's one category of situations where I think people lose credibility and don't realize that that's happening. And then the other situation, which I feel like sometimes I see people lose credibility in court, is that I can tell that they haven't done their homework. And so I'm asking them a question and they don't know the answer. And you know what? The best is to never be in that position, because you've done all of your homework 6 times over and you know the answer to everything, but all of you where you don't know. And I think it's so important in those instances to say, I don't want to misspeak. It's very important to get this accurate. You could say, I suspect the answer is X, but I'm not 100% sure. And I really appreciate the opportunity to submit a supplemental briefing afterwards, to submit a 1-page declaration to make sure I get you exactly the information you need. That is way better than making it up and then later having to tell me it's wrong or misrepresenting something when he didn't intend to. I think that those are the 2 areas where people end up getting into credibility traps, where otherwise totally well-meaning, good people, as almost everyone who practices in front of me is. But those 2 things can be very damaging to your credibility, and I remember it. So it's really important to just to own your bad facts and not be afraid to say when you don't know.
so we've touched on some of this, but I'm wondering if you could share with folks what sort of the single biggest mistake an attorney makes in front of you might be. And happy to hear, any examples or stories you have on that front, but anything that sticks out as a mistake that really attorneys should avoid at all costs. Judge Ilston?
I have an example. It all comes back to telling the truth. I mean, that's the big problem, is if either you don't tell the truth or it seems like you didn't tell the truth because you hadn't done your homework and you didn't have the information. But I did have a circumstance one time when we had a fight about in document discovery, and a particular document had been had been referred to in pleadings in the case. The other side asked for the document, and the person with the document didn't want to give it up. So there are all kinds of reasons why they didn't want to give it up, but ultimately they had to give it up. They gave it over. And it turned out it was a declaration from a declarant about something that had happened in the case. So first there's a huge fight to get it, which was unnecessary. Then they got it. And then it turns out after 6 or 10 or 12 painful months that the declaration is completely fabricated, is completely fabricated. So what happened is, and the only thing I can reconstruct is that the lawyer didn't know that. The lawyer took the client's word for what was going on that and forged ahead. So it tanked the case, to be quite honest. So the hugest mistake you can make is to tell something that isn't true. And the way that you can sometimes wind up doing that is if you haven't done your homework and haven't done adequate, research and vetting to make sure that what you're saying is correct. But it keeps coming back to credibility. If you lose that, you pretty much tend to lose the rest of the case too.
Judge Lynn?
I think another thing sort of in that vein is sometimes I have situations where I have lawyers who are accusing the other side of misrepresenting the record, misconduct, my general feeling is, unless it was really, really, really bad, over the line, and prejudiced you in a way that is irreparable, and only the judge can fix it for you, I don't want to hear it. Because I think the temptation is to come running to us with every little accusation about the other side. You may be right, by the way. So the worst is in a situation where somebody comes running into my courtroom and, usually it's in trial or something like that, and there's an accusation. The other side hid this, did that, and it didn't produce this in discovery. And then here's the other side with the document right there. They're saying base number XYZ, I produced it on this date, and the attorney really has no answer to that. It is a huge credibility hit. So if you were going to accuse someone of misconduct, I think it's really important to recognize what a serious thing that is. And it is not something that you should be doing lightly. It is something you should only be doing after you've done your homework, you've backed it up, and you could tell me why it matters. And then in that situation, I will 100% have your back, and I will make sure it does not happen to you again, and I will make sure to redress the injury that occurred to you. But if you've already 5 times told me that the other side committed misconduct and they did it might be harder for me to notice that that is actually what is happening when it happens to you. So please don't argue. It's really important that I think your professional obligation to one another and to the court, it's important to all of that you take seriously anytime you're accusing someone else of having done something unethical or to have hidden the ball in some way.
It's a small thing, but make good arguments, don't make bad ones. It sounds so obvious, and I've thought of this because my high school debate partner, Andy Pierce, is sitting over there, and I think of myself as a high school debater, and I didn't understand that distinction. Andy did, I did not. So for me, making an argument was making 15 arguments. It was, I've got this, and I got this, and I got this, and I got this, and therefore I win. Well, of course, that doesn't work in here. When you make 15 arguments, we don't hear any of them. Make the 2 that work and jettison all of the others. Just make the ones that are your best arguments, and anything that is got things that people can pick on or whatever it is, jettison. And just don't be the bad high school debater. Be the persuasive advocate.
May I say, right before I came down here this afternoon, I was talking to my law clerks, unsuccessfully, I might add, soliciting jokes so that I might amuse you. I didn't get that, but I did get a a response about what Joe was just talking about, which is we have a motion coming up Friday. And we were talking about the briefing. And my law clerk was saying, well, it's really difficult to get this down because in response to the motion, the party opposing the motion made 20 or 30 arguments. They made argument after argument, and none of them really gets to the meat of the matter. So I feel, my clerk says, like I'm doing all the hard work. Instead of them doing the hard work, I'm getting this motion straightened out, and it's frustrating. So it's kind of what Joe was just saying. Pick the good spots. I know when I was a lawyer, this is one of the things I wish I had realized then that I know now, that we did believe in the throw the spaghetti on the wall theory and see what would stick. That was an accepted practice, and it isn't right. It isn't right. It makes us do more work than we need to, and of course that makes us crabby, and you don't want us crabby.
Judge Lynn, I'll start with you. Any particularly memorable stories of attorneys behaving well in your courtroom or exemplifying the qualities you were talking about earlier that you want to share?
Yeah, I mean, I've definitely had, I think the thing that I appreciate most at oral argument is really attorneys who can see both the forest and the trees. So often I'll put out in advance of oral argument a list of my top 4 or 5 questions. And those questions are the questions that I think are close calls in the case and where I don't feel like I've got enough from the briefing, and I want to give that side one more chance to tell me why I should come out in their favor. And probably I'm leaning against coming out in their favor, but it's an opportunity for them to convince me otherwise. And I feel like the attorneys who do best with that are the ones who come in and they tell me kind of on a big picture level why this is the right outcome in terms of the development of the law, the way this rule would apply in other cases. And they tell me the small picture. They can point me to, in the record, at this page in the record, or this exhibit to the motion to dismiss, the RJN on page 16 has the information that you were looking for that we didn't point out maybe as clearly as we could have in the brief. This is the language in the contract that matters. It is so helpful when someone has kind of both the big picture and the individual, narrowly tailored piece of information that is most likely to be helpful for me. And I think that the attorneys who do that best approach with a attitude of they want to help the court get the information that we need. I'm only asking questions because I want to give an opportunity to the person to help me. So please help me. Please help me with the issues that I think are the most difficult, and that will help me rule in your favor. And I think people who approach it with that attitude are the ones who are really successful at oral argument.
Judge Spiro?
Yeah, I can think of a couple of examples in the same case where people approached that exact problem in 2 very different ways. One, it was a patent case. I was fairly new to patent law at the time, but I'd figured out the technology and the question I wanted to ask. And I asked this long, convoluted question that I think everyone thought got to the heart of the issue. It also telegraphed how I was thinking about it. And the party that was on the slightly better half of that winning, I've forgotten his name, but he got up there and he did exactly what Judge Lynn is talking about. He went and provided me with the pathway to where to put the facts together in this convoluted and ever-changing area of the law to get to a result. And so he had a long argument, and it took like a half an hour on this one point. The other side, also another brilliant, very famous patent lawyer, said to me at the end of the argument, Judge, I think that we're not going to present oral argument. because he had figured out he wasn't going to be dishonest. He was going to talk to me if he talked to me, but he wasn't going to help me get it right. So rather than be dishonest, he just said, Judge, we'll stand on our papers, which was really interesting. So I went one way and we got affirmed, but without his help.
Judge Elston, anything stand out for you?
Well, if we're talking about oral arguments, I just always felt that the most effective oral presenters are ones who can engage in a conversation with the court. If the court has a question for you, answer it. And the more conversational the relationship can be, the more likely we both are to learn from it and take away the important points. So oral argument is an opportunity to engage in that kind of conversation. I don't think we need to make it argumentative. Sometimes the better thing to do is just talk it through, as Joe was just saying. So I think that is very effective. The only observation I was going to make about a good thing I saw in trial, a lawyer that I had a lot of trials with, who was actually quite a contentious person, but she had a really interesting way of doing it. And if she asked a question and didn't get the response she felt she needed, she'd say, thank you for that response, but my question was a little bit different, and then ask the question again. And she would keep doing that until she got the response that she felt she was owed on the question, which I just thought was a very effective way to go about doing it.
So sticking with oral argument just for a moment, I'm curious how you prepare for oral argument now, and how that's different than how you prepared when you were not on the bench.
Let me go first.
Sure.
It's a lot easier now because I have absolutely brilliant helpers. We all have brilliant helpers. So I'll just say for me, what I in an ideal world, we have 2 weeks between the last brief and the oral argument. So in an ideal world, during the first of those 2 weeks, a law clerk will read everything. I will talk to that law clerk and find out what the issues are in the case. The law clerk gives me a memo. I then read the briefs, read the memo, but much closer to the date of the actual oral argument. And then we may have some questions that we want to have for the lawyers to respond to. But so my answer is reading the briefs and reading the memos that the law clerks prepare. The latter being a huge assist. And we are very, very grateful to our law clerks.
Judge Lynn?
My process is really similar. The first week, the law clerk is reading the briefing, and I am usually, I read about half of them before we have a weekly meeting, and about half of them after. But we have a weekly meeting every week. I have all of them on Tuesdays, and on Wednesdays, my law clerks and I have a big meeting where we go over everything that is on calendar on Tuesday. We talk through their recommendations. For the cases that are more difficult, usually I will have read the briefs already. For the cases that I think will be more straightforward, I haven't read them yet, and I will read them after I talk to the law clerks. We don't do bench memos. We just do an oral presentation where we try to focus on the issues that are likely to be the most difficult. And then once I get a sense of all that, I figure out which cases will stay on calendar for argument on Tuesday, and which cases I think we should just take under submission because I don't have a lot of questions and it's pretty straightforward. So I'm usually making the decision Wednesday and Thursday. So those 2 days are pretty intense for me as I'm reading all the briefs and try to get done with all the briefs around Thursday so I can make the call as to which cases are on for Tuesday. And if I am going to have a case on Tuesday, I'll usually put out my top questions on Thursday or Friday, just because I feel like it helps me get better answers. If I can give the lawyers an opportunity to prepare and know, what it is that I'm worried about, or if it's tentative, I will sometimes just do like a page and a half just summarizing what I think I'm generally deciding in the case, and my tentative decision generally in the case, to give them an opportunity to respond. The other reason I do it that way is because I think it allows the lawyers to put forward more new associates to do oral argument, because they can take, one of the questions that's less important. I think that it gives the clients of the senior lawyers a little more confidence that, the junior lawyer will be adequately prepared because they know exactly what the question is and exactly what that person will say. And so it's my hope that will permit more people to take a little bit of early stand-up responsibility, which I think is just so important. It was important for me in my career, and I think it's really important to the development of new lawyers.
Very similar process. The one thing I will say is I'm not nearly as kind or as well prepared as Judge Lynn, so I don't put out something in advance. I got on the bench and asked my questions. But that also, it struck me this morning when I was thinking about it, is that's the piece that's very similar to preparing for oral argument as a lawyer. As a lawyer, I always try to figure out what are the troubling pieces of this that the judge will ask about. And now I just figure out what the troubling pieces are and ask about it. So, but it's not, it is, so it's, I have a little better insight into what the judge will be asking, but it's a very similar process, looking at that case and figuring out where the holes are, where you need to figure something out. But otherwise, a very similar process.
So switching gears slightly, we have a pretty wide variety of experience levels in the audience. And I was wondering if you had particular habits or advice that you might provide for attorneys who are more junior versus more experienced in terms of things that are effective in front of you. Judge Lynn, can I start with you?
I think for attorneys that are more junior in general, some of the best oral advocates I've had in my courtroom have been the junior associates who have read every single case at issue, know the law inside out, know the facts inside out, and wrote the brief. I've had great oral advocacy from those folks, and I think for them, I think the challenge is just making sure that I think one of the areas that's the hardest for them is when I'm asking them for concessions in the case, because they are nervous that somebody higher up, the client will get mad at them for saying whatever it is that is true. And I can see that, and that fear in their eyes sometimes when I'm asking them. And I think that what is really important when you're in that role is to try to anticipate what you think those things might be. Because you will be in a much better position if you have pre-discussed that with the people who are on your team, so that they will be comfortable with you making the concession when push comes to shove. So I think that that's something that would be really helpful for junior associates to sort of focus on in the process. Honestly, I think a lot of the rest of it comes easily to them because they already know the law and facts well. The only other thing I'd say for junior lawyers is sometimes there's the temptation to make the 16 arguments instead of the 2 best ones. So you have to just develop the confidence to edit down what your responses are going to be to the likely difficult questions that either the judge is giving you in advance or that you foresee that the judge will give you.
Yeah, that's completely fair. Some things are pretty elemental, but if you're a junior lawyer just starting off, the elemental, don't make all 14 arguments. Don't talk fast. Talk slowly. We won't understand you unless you talk slowly. Don't rush through the argument. Make your arguments. And then it's something that even senior lawyers have a problem with, but it's very important, is the most important questions are the questions that the judge asks you. And so focus on those. As a senior lawyer, presumptively, you've got to figure out what the judge wants and give it to them. as a new lawyer going into your first oral argument. I can remember my first oral argument before Judge Legg, which I completely blew. I made every possible mistake. I made my speech rather than listen to his argument. I overstated my arguments. I made too many of them. It was a class in how not to do it. He was a very kind judge. So now, Mr. Spiro, you should slow down and you should do this. Don't overstate it was a teaching moment for him. It was great, so it's a teaching moment. Go slow, make your best arguments.
Judge Elston, anything to add on that?
Well, I had a teaching moment one time with a more experienced lawyer. Early on, I had a hearing for a preliminary injunction in a trademark case, which had to do with ski jackets. So the plaintiff sold ski jackets that had famous marks on them, and the defendant sold ski jackets that had other marks on them that the plaintiff felt were too similar to the plaintiff's marks. What I knew at that time about this area of the law, you could put in a thimble and not fill it, as my partner used to say. But we were out there having the oral argument, and the senior fellow was up arguing on behalf of the plaintiff. And from time to time, one of the lawyers at the table, his table would come up with a little yellow sticker and hand him the yellow sticker, and then he would continue on. And I said, if your colleague would like to just share with me directly what he's giving you on the yellow stickums, that would be fine. And he said, oh, well, that's all right. We don't need to do that. And the case went forward. So we had our argument on that motion. And then within a few weeks, that was a preliminary. So we came on for the permanent. And by the time of the permanent argument, she was a female lawyer who had been doing the yellow stickums, was by now the lawyer arguing the case. She made a fabulous argument, and they did really well. So I felt that I was helping the older lawyer understand that the younger lawyer had a lot to offer and maybe should be allowed to do it directly. So I just enjoyed watching that play out. The other thing, not about arguments, but all of us have case management conferences from time to time. And these are non-adversarial. We sit around the table and talk about the case, what's going on with the case, what are the next steps. These are really important times. I think people don't take them as seriously as they should, because they're valuable opportunities to steer the course of the case. And for these, very often the younger lawyers are the ones who are made to go to them, and the more senior lawyers don't. And we get to the problem that Rita was talking about, which is at case management conferences, you will be asked to make concessions, and these concessions may help your case a lot. And if you're in a position where you say, gee whiz, I don't know, I'll have to get back to you on that because I have to talk to the muckamuck at my law firm, you've missed an opportunity. So for the case management conferences, I think that lawyers miss an opportunity if they don't send the senior lawyers to those. Junior lawyers for sure can come, but they're not without value, these conferences. So I think it's important to have somebody there in a position to make decisions, because you may be called upon to do so.
So that brings up one thing I wanted to ask about, which is, are there different issues from your perspective facing solo practitioners or small law firm attorneys versus attorneys who practice at larger firms, and how do you see those? I'll start with Judge Spiro.
Sure. It's starting with the big firms. I think it's often lost in the shuffle when we have a large team of lawyers in front of us that the number of people working on your case in chambers is 2, each of which has 300 other cases to work on. An unbelievable number of cases to work on, and that when you prepare things to present to the court, they ought to be done with an eye towards a person who has very little time to look at what you're looking at. It is, I had a case in the last couple of months, big teams on both sides, big summary judgment motion in a very complicated case in which there were, 1,000 exhibits all told, not individually identified on the docket. I mean, it hard to access, made the Joe Spiro as a high school debater mistake of putting all 75 arguments out there. So it just, when you've got two people to sort through that, and you've made it impossible to do anything other than make it up on our own, you hurt yourself. And so I think with big teams, that's one of the challenges, is making sure, despite the firepower you bring to it in terms of people power, to make it so that one or two people with very little time can get through it and get to the end. For the solo or small practitioner clients, firms, I know that when you get to trial, you are buried. I mean, it's a double time, triple time job, especially if you have a big team on the other side. And there are small things you can do to make the judge's life easier. I assume you'll be as efficient as possible because you don't have presumably the inclination or the wherewithal to put the 1,000 exhibits when there's only 3 that you really want the judge to pay attention to. But put them together in the way that the judge wants. Put them together in the way that the judge's rules say, so there's no extra little annoying step in the way of the judge accessing your stuff. Maybe those are the same thing. I don't know.
Jalen?
Yeah, I mean, I think a lot of this were on my list too. I mean, I think when I walk into the courtroom for trial, for pretrial conference, and I look out and I see teams of 20, 30 lawyers on both sides, the first thought in my head is depending on the litigation conduct earlier in the case, typically the first thought in my head is, I need a way to get the motion practice in court during the trial under control. Because if I look out and I see that number of lawyers, I'm immediately thinking you're probably going to be filing 15 motions every night. And I am one person with one law clerk who is working on the trial typically. And so then if you do not come to me with a plan, how you will make my life livable, I will come up with a plan on my own. So, for example, in the last, I had a trial a while ago where I ended up just telling the parties that they couldn't file papers during the trial without permission, without raising it orally with me first. And then we had a system where every morning they would raise issues orally with me for a maximum of 30 minutes, but the losing party would have the money charged off their trial clock. And after, there were a couple evidentiary motions that I think were pretty clear how they should come out. The losing party lost an hour off their trial clock. Then the result was I had very few evidentiary disputes during the trial. We had no paper motions because people made educated decisions about which evidentiary motions matter. And I said and love having that approach because I worried that I was forcing people to edit more than they should have. And I would have really appreciated it if the lawyers had come to me with a plan for how they could keep the motion practice at a manageable level. So I think that's a long way of saying for those who are at large law firms, I think the judges are looking at you when we go into trial with a conception of what you might be doing to us. And it is to your advantage to think about ways that you can proactively let us know that you will address it, that you have a system for, stipulating to exhibits. This is what it's going to be. We're going to meet and confer every night at this time, that we will file our motion. It will be no longer, all the issues will be addressed in one motion. It will be no longer than X pages, and it will be on your desk by 6 p.m. so that you can spend your evening dealing with that each night during trial. And I personally at least appreciate that kind of foresight from the larger law firms. For the smaller operators, I think one thing I guess I would say is that trial presentation is really important. And I know resources are scarce, but I really appreciate, even from folks who I know have scarce resources, when they put in the time and energy to having a visual presentation that is smooth and that works. So, we have courtroom technology in all of our courtrooms. It's the same. You can plug it in, show things to just the witness, and then show things to the jury. If you know how to use it, it's cheap, easy to use, and will make things smooth and save you a lot of time on your trial clock. And I really appreciate it when folks, take the time to learn the technology, to come in, work with my courtroom deputy, and make sure that they can present things in a way that is smooth for the jury. It saves everyone a lot of time and it gives you credibility in the trial process.
Judge Ilston, any thoughts on solo, small firm versus large firm?
Yeah, my thoughts were wandering back 35, 40 years, because I was in the small firm. And I remember one day in trial, at the end of the day, the judge said, well, what about this? What about this? Why don't you have your night crew do a little brief on this for me? And I looked up and said, I am the night. So the flip side of all the things they've just been describing happens to folks in smaller settings. So I just, as a judge, I'm at least somewhat empathetic still. I still remember a little bit about what it was like to be going through that. And that's another reason not to have all those motions come in every single night, because if the opponent is truly in a small situation, why that really puts a strain on them. And by the time you're in trial, there's just no excuse for having to have brief after brief after brief every night. So we should arrange things better so that that doesn't have to happen. The good thing, though, about being in a small firm is that you get to do everything sooner than you would in a big firm, and you learn how to do it. And sometimes you even learn how to do it really well. So it's an opportunity to actually practice law that is provided. So when I talk to law students, I always tell them, don't overlook the prospect of being in a small situation rather than a big one, because you will be able to move at your own pace, and sometimes that can be a lot better.
And sticking with you for a second, Judge Ilston, do you place any significance on whether a party attends a hearing or a trial?
Sometimes, and I'll tell you what I mean by that. Not for oral arguments on just motions and things. I would never expect a party to come to that. They can, for sure, but we don't expect it. Certainly don't think anything about it if they're not there. Now we do so many things on Zoom that it's almost divorced from who's in the room. So I think you may have your own reasons to want your parties to come, but in terms of affecting me anyway and how I think about the case, almost never does it matter. Sometimes it matters, though, and here's an example. I just had a trial a couple of weeks ago, and my concern in the trial was that the amount in controversy was relatively small, and the lawyers for each side were from out of town. And I was starting to add up the amount of money that trial was going to cost versus the amount of money that was at issue in the trial, and it was making no sense at all to me. So at the pretrial conference, but we had been through unsuccessful efforts to resolve it, and it was clearly going to have to go to trial. So at the pretrial conference, I said to the plaintiff's counsel, well, I see that the plaintiff isn't here. Usually by the pretrial, the plaintiff comes. Where does the plaintiff live? And the lawyer said, geez, I don't know. This was a very bad thing, because a part of this means that if the plaintiff is from out of town, the plaintiff is going to need a hotel room too. So all of a sudden, all of the costs are mounting up on a case that didn't have that much. Generally, I don't think it matters if the party comes, although I think it probably is a good thing for the lawyer to have the party there from time to time. From the court's point of view, doesn't much matter. It is important, I think, at the pretrial conference and of course at the trial. And even though the jury will be instructed that if a party has to pop out for a day or two because they can't stay for the whole time during the trial, the jury thinks, I got to be here for this trial. So they ought to be here for this trial. So you ought to do everything you can to make sure your client stays all day, every day for the trial.
Yeah, I agree with that. I think it matters for trial. The jury wants to see your client there for trial. I don't care at bench trial, but the jury cares at jury trial. And otherwise, I don't have a reason that I think the parties need to be there. I do think it's obviously it's different in the criminal context where the defendant needs to be there.
We do so many things
In the criminal context, it can make a difference for me if the question is at sentencing what someone's prospects are and their likelihood of being able to stay on the straight and narrow. If you're asking me for a non-custodial sentence, I think having family there is really important to me, and it shows that somebody will show up, be there, and say that they're there to support the defendant and make sure that they stay on track. It's definitely something that I factor in and is important to me in the criminal context. I guess the other thing I'd say is that sometimes there's lots of people who will show up to support one side or the other. I don't find that affects my decision making, except in the sense that it makes me conscious of the need to write my decision or explain my decision in a way that lay audience will find more accessible. It's just a reminder to me that of both what the stakes are, but also just that there are people who care about this who may be non-lawyers, and it can affect how I write the decision, but I don't think it really affects ultimately the decision-making process.
The one situation in a civil case that occurs to me, and it's happened a couple of times to me, and maybe it's to you, is the times when your client has unrealistic expectations about what the process will yield. And sometimes having them witness the process can change those expectations. I've even gone so far as to be in the frustrating position that Judge Ilston found herself in with a very small amount in controversy and a very large attorney fee and cost bill looming, to make sure that the plaintiff and the defendant individually showed up at the pretrial conference so they would see what they're facing. Not really lecturing them, although I'm not above that, but just so that they know that, it may not go the way they're expecting. And from your perspective, if you get the sense that the client is, resisting your advice, difficult to redirect even based on sensible predictions about how things are going to go and what the judge is going to do, et cetera, have them come and watch. So they will know firsthand that you're a brilliant lawyer and you know exactly what you're talking about, but the problems they face. And I think I've only had a couple of occasions where that's actually, been obvious to me that people were there for that purpose in the past 25 years, but occasionally it's a good idea.
Yeah, I would say that I've had situations at case management conference where I've gotten the sense that, our case is stalled out because one of the parties will not give their lawyer the time of day in order to produce discovery or to there was foot dragging on the client end, and I could just tell from the way the conversation is happening. And sometimes in those situations, what I will do is make a big speech about how this is a big problem and that, it seems like one side isn't taking the case seriously. And if we need to, I'm going to have a conference, and sometimes I'll talk about potentially having that party come in so that they can understand what the process is. But, part of the objective I have in making that speech is to give the lawyers the sound bites that you need to go back to your client so that your client will give you the time of day so that you can fulfill your obligations to the court in doing discovery that needs to be done. And so sometimes I'm doing a little bit of a performance, but it is for your benefit so that you can play it for tell your client about it, or, get the transcript for your client, replay it for them in your retelling so that they will do what you need them to do.
And Judge Lynn, sticking with you, anything in trial that's particularly effective you've seen, whether Superior Court or here?
I think that one of the things that I'm really conscious of is in that I wasn't as conscious of when I was an attorney is how important opening statement is at trial. Just seeing a really effective opening statement that is simple and straightforward and tells your story first, but also anticipates a little bit what the other side's story is going to be and accounts for it is so powerful. And I think one of the things that I'm always reminded of every time I see a really outstanding opening statement is how much lawyers who are good at that recognize that the jury can only absorb a bit at a time. They go nice and slow, and they cover very kind of clear-cut themes. They tell the narrative a couple times maybe, but in a way that's not too detailed. And I think it's so important. It sets the table for the whole rest of the trial. So it's always fun to watch when folks do that with a lot of skill.
Judge Spiro?
It's the thing that comes to mind for me, which is kind of a simple thing, is people don't know the rules of evidence. It's astonishing. Maybe it's a fat part of the problem is we have so many litigators who have so little trial experience. But even if you don't have a lot of trial experience, you can study the rules of evidence and how they work because and have planned out how you get in each particular piece of evidence that you want to get in your case and not do it on the fly and not do it stupidly and not make a mistake. That's sort of elementary. You should be able to, that's a piece that you can plan all the way through from beginning to end. And it's amazing to me how many people don't do that simple thing. And they'll try to get something into evidence as a business record. They won't have the slightest clue as to the predicate questions they need to ask to get it done. And move it into evidence. Denied. What? It's just, and that's just an example. It happens so often. It's very frustrating to a trial judge. It's very frustrating to a trial judge.
Judge Olson?
Just wrote down time because no jury ever complained that the trial was too short or that they went home too early in the day. The big complaint juries have is about their time being wasted. Do the lawyers think I'm an idiot or what? Which has to do with repetition. So all the things that Rita was talking about are really important. Respect the intelligence of your jury. I find that I've been now 31 years at this, and I am still less able to predict with precision what the jury will do than my courtroom deputy. The courtroom deputy always gets it. And I think actually the jury is really close to right about almost everything. It's a very intelligent group. And the one thing that I will say about lawyers and juries, and this is, I don't know if this is helpful or not, but it matters if the jury likes you. It really does. I will find that the courtroom deputy will tell me, well, you know, this side's going down in flames. And I'll say, why do you think that? They don't like the lawyer. The lawyer's being obnoxious or whatever. And sometimes it's not even that much being obnoxious, but certainly if you're arrogant or even hostile to the other side, that can affect the jury. But if the jury likes you, it really, really helps in terms of the result you get in the case. So however you comport yourself, it really helps if they like you.
Yeah, I actually think like there's another shade of that too, that it's the jury, whether the jury thinks you're trustworthy is really important. Like, even more than necessarily liking you, some people can be, you know, entertaining and personable, but if someone seems trustworthy, like they're there to help the jury get to the truth. They're not hiding the ball. They're not saying, you know, making little comments or being unreasonable. They are just trying to get to the truth too. I think that frame is so persuasive to them.
So I have one last question, and then we have a few minutes for questions from the audience. But the question I had is, what do you wish you knew when you were on the other side of the bench? Judge Elston?
I have a very non-profound thing to tell you. I used to believe a lot in adjectives and adverbs in my briefs. You know, punch it up, punch it up, punch it up. And I had helpers who were helping me even at the firm. I'd say, punch it up. And I have discovered as a judge that was bad advice to myself. I so admire people who can write clearly, lay out the argument, lay out the facts. I don't need adverbs and adjectives. I need to get what the facts are and why I should do what I should do. And I noticed Friday I had a hearing, and I had read the papers before, and there were a lot of adjectives and adverbs in this one brief. And then the lawyer came in and argued the same thing all over that was in the brief and used a lot of adjectives and a lot of adverbs. And I found myself sort of tuning out after a while. So that's what I wish I had realized at the time.
Judge Lynn?
I guess I would say that I didn't realize how long the judge's memory is of who appears in front of them and their impressions of them. Now that I've been on the other side of this, it was kind of shocking to me. I guess it's kind of shocking to me the extent to which judges talk about the lawyers that appear in front of their courtroom. Like if I'm going to tell a story in the dining room, and after the entertaining, I get about a sentence into the entertaining story, and the first question is from everyone else, which lawyers was that did this outrageous thing in your courtroom? And I think it's human nature that it's a small bond, and we think about what you do in front of us, and it's important to us. And when folks have really distinguished themselves by being excellent and trustworthy and made our jobs straightforward, help them. I mean, we talk about that too. So it's not just bad stuff, it's good stuff too. But I think I didn't realize how much judges actually clocked that information without necessarily overtly reacting to it in the courtroom. So I guess that's the biggest thing that was surprising to me after ending up on the other side of this. But I think that kind of speaks to a lot of the themes we were talking about how important it is to maintain your credibility and your trustworthiness and your attitude of helpfulness towards the court and the jury.
Judge Spiro?
Yeah, I was going to say exactly what Judge Lynn said. And although I will tell you that at some point judges start to forget, but that's a different question. but credibility is key. The other thing I guess I wish I had thought about earlier was how important it is to becoming a trial lawyer to get trial experience. And, you know, again, it seems sort of obvious now when you say it out loud, but when you're a 25-year-old litigator in a firm that occasionally goes to trial, it's not all that obvious because, you know, we're all smart. We can figure everything out. We can do anything we put our mind to, blah, blah. No, it doesn't actually work that way. So getting, you know, finding other opportunities to get any kind of trial, it doesn't matter what it is, whether it's being on a loaner to the DA's office or the public defender's office or doing pro bono trials or whatever it is, so that you get to stand up there in front of a jury and put something into evidence and do a cross-examination that doesn't go on and on and on and makes no points. You know, so I don't think I appreciated that for most of my career, how important it is to get into trial, to becoming a trial lawyer.
So I think we have a few minutes remaining, and I want to open it up to questions if there are any from the audience. I can repeat because I don't know if we have a microphone to pass around, but any questions from folks? Yes.
We've all heard about bad things about AI. Judges have had positive experiences with AI courtroom.
So the question was, we've all heard some of the bad things that happen with AI. Have you had any good experiences with AI in the courtroom so far?
So the only thing I would say is two things. One is the best AI is invisible to us. They don't get caught. They do a great job. We don't even see it. In discovery, we know that and what people are doing using AI to sort through massive data dumps and that sort of stuff. And that, I think, has been tremendously effective. People negotiate endlessly about what the parameters are for what's going to search through what and how they're going to do it and you know what the particular program is that they're going to use. But that kind of use of AI has been a tremendous boon to large cases.
However, pro se litigants have discovered AI as well.
Yes.
That's the challenge.
Yeah.
I actually have a different perspective on. I mean, I think sometimes the pro se's having discovered AI has actually been really great because they've been able to figure out how to put their argument in a box that actually makes a little more sense. I had a conversation the other day with someone I know who does ADR work, and she was saying that she had a pro se person that she was doing an ADR session with, and that person kept clearly consulting AI in between each of the kind of back and forths that they were doing in the mediation session. And the person kept coming back with exactly what you would expect counsel to be telling someone in that situation. That ultimately the pro se ended up at a resolution that was the right one, and it was the number that made sense. And in some ways, having the AI there for that litigant was what helped her have a really effective mediation, which I thought was pretty cool.
I think that's right. The problem is they don't have the ability to distinguish correct from incorrect. And so I've had a couple of pro ses, despite repeated warnings, have hallucinated authorities, and their cases went out on having hallucinated authorities. So they lost their case because they used AI. But I do agree, it does help them. It can make the legal process more accessible if they have a way to manage the pitfall, which is it can manufacture things that aren't true.
Other questions from the audience? Yeah.
So my question is kind of on the AI, but any thoughts of using the technology to streamline the process? And that's when you issue the documents, we're still printing on the pages, one-sided, and submitting digital submission of those documents. Having that as so that we can run into the faster delivery to those documents. The second is where the AI will be good, which is coming good actually very fast. Judges can use that to corner those things. So any thoughts on improving from paper printing submission to digital print submission.
So the question was, any thoughts, I think, from the court's perspective on using AI to improve litigation or court processes, or I assume your decision-making processes, using it in chambers, anything like that going on?
I mean, I think generally most people are not using AI in chambers because of A, confidentiality concerns, but also B, I think there's a real accuracy concern. I mean, maybe when we get it a different generation of the AI, when it can be more reliable, it will be more helpful. But I think in a world where I have to be highly accurate, it's not that helpful to have something that is generating something that I can't necessarily rely on. But I do think that it helps. There's some AI built into the Lexis and Westlaw now, and I think that parallel search and stuff like that in Westlaw. I mean, my law clerks are much more sophisticated about it than I am, but I think has helped legal research just in terms of finding the thing that is really helpful. But I think at least, and I think many of us are in the same place. I'm not yet at a place where I could feel comfortable outsourcing any part of the writing and analysis to AI. Even just summarizing the factual record makes me nervous if I'm not sure how accurate it is. But I'm sure it can be helpful for the parties in preparing the summary as long as they're able to validate what the AI has put together and make sure that it is helpful to the court.
The same wording which is that will be done. I'm sorry, that was not my question. My question was, can we digitize all papers we have to submit to the court? So no printing, no killing the trees. Everybody has to submit a digital card online. So that one thing is, it's much faster. Second is, when AI, the judges, so I will cross the AI out, because it's still in the development stage. But at least we'll stop the papers, bring the efficiency, and the judges don't need to go through the PDF, all those things. It's like,
So I'm already there. I never use paper. I look at everything online. I never look at any paper. My law clerk will sometimes use paper, but whether it's in oral argument, in a motion, or in trial, or whatever it is, I only use the digital copies.
Me too. I think our whole system is digital in the federal. I mean, it's all e-filing except for pro ses. But I'm sure there's more we could do to make it more easily accessible, so that public court records could be ingested and analyzed, and help the development of technology that will help us help you all.
Mm-hmm.
So I think we're at time. I want to remind folks that there will be a reception immediately outside the courtroom. And please join me in thanking our panelists for great discussions tonight.